Hello, my name is Michael Tessaro and I prepared this presentation entitled Cupping or Whupping, ASIC and Insurance Australia Limited. And in this particular presentation, I'll be looking at the recent decision by Abraham of the Federal Court in relation to IAL. And the point of the title of the presentation, Cupping or Whupping, relates to this algorithm implemented by IAL called the cupping mechanism, which resulted in the level of discounts being provided to customers being reduced. And they were fined for $40 million in relation to this conduct. So I guess it's, in my view, IAL has cupped a whupping in this particular case by ASIC. And I must admit, I love that cartoon there. It just sends me into hysterics every time I look at it. Now, a bit of background about myself. I'm a competition and consumer lawyer, and I run my own practice, Tessaro Legal Consulting, and I help companies with competition and consumer law matters. I've been doing that for the last 15 years. I also do consultancy work for a number of legal publishers on competition and consumer law areas, including LexisNexis, Wolters Kluwer, and CCH. Prior to that, I worked with ACCC for 15 years in a variety of roles, including as Director of Enforcement. Now, the outline of the presentation is pretty straightforward. I'll start with the background to the case, then look at the facts, then look at the decision of Abraham, and then finally finish with some commentary. Now, a bit of background is important. I've put the full name of the case there. It's a bit longer than on the first page. And as you can see, IAL was ordered to pay penalties of $40 million, so that's very significant. And I included a definition of whupping for people who may not be familiar with the term, and it is to beat soundly as with a whip or to defeat totally and overwhelm. So I think it's fair to say that IAL cupped a whupping in this particular case. Now, the background to the case was IAL was offering these renewals, and these are key, very well-known NRMA insurance policies in relation to motor vehicles, homes, boat and caravans. So they're offering these policy renewals to customers. They sent this certificate of insurance, or a CIO, to their customers, which set out the details of the discounts that the customer had purportedly been given, consistent with NRMA's policies. Now, the COI represented that the full value of these discounts had been applied to the premium and the customer was getting everything they were entitled to. Now, the thing that customers were unaware of was that the insurer had applied this algorithm called the cupping mechanism to all these particular policies, and this algorithm was triggered when the renewal premium fell below an amount set by IAL. So effectively there was a set percentage, and if the discount was going to push the premium below a certain set percentage, then the cupping mechanism pushed the amounts up to a higher level. So as you can see, when that occurred, the customer's premium before the discounts was applied was recalculated and increased. And the result of this particular conduct was that for those customers who had the cupping mechanism applied to their renewal premiums, they firstly paid higher renewal premiums than they should have, and they also didn't get the full value of the discounts that they were entitled to under IAL's policies. And as the judge said, put another way, the cupping mechanism limited the extent to which the promised discounts were provided to the customers. Furthermore, this wasn't visible to them. They had no way of knowing what was going on. They had no way of calculating. So even if they sought to calculate and review the COI to work out whether they're getting the full discounts, they wouldn't have been able to work it out. And as you can see, the judge noted that IAL did not disclose to its customers the existence, application, or consequences of the cupping mechanism used to calculate their premiums. Now, some of the background information that's relevant is the relevant period was actually from March 2014 to September 2019. So the period over which the cupping mechanism was applied was over 5.5 years. However, due to statute of limitations issues, ASIC could only seek a penalty in relation to a shorter period of time from October 2015. So the period from October 2015 to September 2019 was considered the penalty period over which ASIC could seek to obtain pecuniary penalties. The conduct impacted 611,000 groups of affected customers and approximately 705,000 different policies. So it's quite wide ranging. And it affected or impacted those affected policies almost 2 million times. So this cupping mechanism was applied in relation to 1.7 million premium amounts. So on 1.7 million occasions, the customer actually paid a renewal premium that was higher than they should have paid, than they are actually entitled to. And the amount of financial benefit to IAL was quite significant. So they made an additional $60 million from this particular cupping mechanism. And once you look at the GST, stamp duty and FSL, the customers were actually out of pocket by $71 million. Now, IAL did admit their conduct was in breach of the legislation, and they admitted there was two representations that they made which were false, misleading or deceptive, which was the premium misrepresentation. So they told the customer that their premium was a certain amount when that was not true, and they also committed the discount representation. So they falsely told customers that they were getting the full discount they were entitled to when they weren't, and that conduct constituted breaches of sections 12DA1 and 12DB1G of the ASIC Act. They also admitted breaches of other obligations. Firstly, given these were insurance contracts, clearly there was a breach of the duty of utmost good faith by IAL, and also a contravention of section 912A1C of the Corporations Act. So IAL admitted all the contraventions alleged against them by ASIC. Now, the specific misleading and deceptive conduct was set out by the judge. Firstly, they limited the extent to which the discounts which customers were entitled to, so they misled their customers about the level of discounts. They also increased the base premium before the discounts were applied so that the customer wouldn't get the full discounts that they were entitled to. By increasing the base premium before discounts were applied, they charged the customers higher premiums than they should have. They also did not calculate the premium payable on renewal consistently with the information provided in their policies. And finally, they failed to disclose the existence, application and consequence of the cupping mechanism. So they're the false and misleading representations which IAL admitted to making to its customers over a 5.5-year period. Now, it's noted by the judge at paragraph 15, I think this is very significant, these contraventions occurred in the context of IAL intentionally designing, approving and implementing the cupping mechanism, where one of the considerations for its approval and implementation was its potential loss of profit if the cupping mechanism was not implemented. So the keys there is that it was intentional policy and it was aimed at increasing the revenue of IAL. If they hadn't implemented the cupping mechanism, they would have been $60 million down in terms of revenue and also significantly down on profit. And then, as you can see there, the judge turned to the question which they're required to consider in all penalty decisions, as set out by the High Court of Macquarie, is to consider the maximum penalty that could be applied to the conduct. And as you can see under 12GBA, the maximum penalty in the relevant period was 10,000 penalty units, which, depending on when it occurred, would result in a penalty of between 1.8 million to 2.1 million. And the number of contraventions was actually 1 million contraventions. So as you can see, if you go and do the maths, you're multiplying the minimum penalty during the period of 1.8 million by 1 million contraventions. So the judge didn't actually do this calculation in the judgment, but if you do the calculation, the maximum penalty applicable to this conduct is actually $1.9 trillion, so almost $2 trillion. So what the judges routinely do in this situation is they refer to Macquarie and then they sort of say that, well, the penalty is too ridiculously big, as it was in this case. We can effectively ignore the maximum penalty and just pick another number out of the air, which is effectively what they're doing in these particular cases. There's no real rhyme or reason why 40 million was determined to be an appropriate penalty. Now, the judge outlined the nature and extent of the contraventions. As you can see, the contraventions involved the making of false, misleading and deceptive representations in relation to very common and popular NRMA insurance branded products. Also, the consumers were at a relative disadvantage compared to IAL. They had no way of knowing that they weren't getting the full discounts. They had no way of knowing the premiums were incorrect or that the information the CIO was not accurate and had actually been manipulated. Also, the conduct continued for a significant length of time. So 5.5 years it was in place, and I guess even looking at the penalty period, it was still a period of 4 years, and the number of contraventions was significant. So the total number of times that the cupping mechanism was applied was almost 2 million occasions, but in the penalty period, fortunately for IAL, it was only 1 million occasions, but that's a lot of contraventions, 1 million contraventions. Also, the judge noted that IAL is a very large provider of these common types of insurance. It has a very strong brand recognition and it's a very popular brand of insurance. And then I added one extra, which I'm surprised the judge didn't include in her assessment of the nature and extent of the contraventions. Given this is an insurance product, it's clear, and there was a finding made, that IAL had breached its duty of utmost good faith to its insurance customers. Then she looked at the circumstances of contravention, and as you can see, the very purpose and intended effect of the cupping mechanism was to reduce the actual discounts provided to customers whose premiums would have been reduced by more than the cup. And I think, the key there is the very purpose and intended effect. This cupping mechanism was devised and implemented to reduce a loss of revenue. It was driven by financial considerations. Then the businesses needed to introduce this mechanism because it wanted to avoid the risk to revenue if the large discounts which were generated under another policy, the Go Discounts project, were actually implemented. So here's a cynical attempt to prevent losing revenue through the application of a Go Discounts project, which IAL was promoting very heavily to its customers. IAL staff were aware before, during and after the implementation of the cupping mechanism that it would operate to reduce discounts. It was also clear to the IAL staff that customers would have no way of being able to determine the cupping mechanism's existence or the way it was operating. So it was a secret mechanism that was not disclosed to customers. And then this is a key point: despite all of the above matters, and despite that one of the very aims of the Go Discounts project was to improve transparency of premiums and discounts, the issue of ensuring that the effect of the cupping mechanism on discounts was apparent to customers was not directly addressed by any committee or forum responsible for initially approving the cupping mechanism. So here they're trying to promote transparency, better discounts for consumers. Then they decide on a new algorithm to prevent that transparency, to prevent those discounts, and nobody picks it up and stops it occurring for a period of almost 6 years. And finally, it was not IAL that actually identified this particular breach. Rather, one of the external service providers pointed it out to IAL, and then action was taken. Now, this is the thing that I find very funny: the conclusion by the judge that the conduct was not intentional. IAL submitted that it's failure to disclose the capping and cupping. So there was also a capping mechanism which prevented some premiums from rising above certain levels. So that's fine as well. I guess that's a positive, but it doesn't take away from the detriment caused by the cupping mechanism. So basically they're saying there was no intent to mislead. The contraventions were not deliberate. That was a submission made by IAL, and then ASIC does not submit that the representations were misleading and deceptive were deliberately or intentionally made in breach of the law. And I just can't see how ASIC is making that submission to the court, because this was a conscious algorithm introduced for the specific purpose of preventing the level of discounts being provided to customers and to reduce a reduction, or to reduce the risk of a reduction in revenue. So how this is not intentional really puzzles me. And then you see the judge accepts the submissions that the failure to disclose the capping and cupping, accepts that there was no intention to mislead. So I find that a very, very strange conclusion to reach, given the way this was brought about. Also, a lot of the internal documents are attached to the statement of agreed facts, which seem to show there was quite a lot of clarity in why the cupping mechanism had to be brought in to prevent a decline in revenue. Now, other factors the judge weighed up. Firstly, she noted that senior managers were aware of the particular product cupping mechanism. So as she says there, ASIC acknowledges that the board was not aware of the cupping mechanism, but senior staff were aware, namely the CEO of Personal Insurance and the Executive General Manager of Product and Pricing. So that you'd see would go against IAL in terms of any penalty. She gave them credit for their culture of compliance. So ASIC accepts that IAL has sought to strengthen its compliance and risk management culture and processes since reporting the conduct to ASIC in 2009. And she accepted that the steps taken by IAL since that time demonstrate genuine steps to embed a culture of compliance. Then she looked at the benefits of the contravention and says ASIC submitted that not only did AIL obtain benefit from the inflated premiums, $60 million worth, but it retained a significant number of customers who, had they been properly informed that they were not in fact being given the full discounts to which they were otherwise entitled, may have chosen to lose IAL, and that was a big concern. They were very concerned, IAL, about losing customers to competitors. If the premiums had reduced by a significant amount, because that would have created a concern that NRMA had been sort of ripping off its customers for many years, and that they now wanted to change insurers. So clearly the conclusion there was a significant financial benefit from the contraventions to IAL. Also, the size of IAL was significant. It had a market share in this particular segment of between 17 to 23%. So that's got to be a market-leading position. And it does have significant assets and annual revenue. Furthermore, a factor that went in favour of IAL was they had not previously been found to engage in a breach of the relevant legislation. Other factors that counted in favour of IAL included their cooperation. So they engaged constructively with ASIC since the proceedings were commenced, early admissions. They have undertaken comprehensive remediation programs. So they basically paid back a lot of the money that they should have paid to the customers earlier, and included interest on that. So the customers have been compensated or they've been given back the money they should have got plus some compensation. They've apologised for its conduct to the customers, to the public, and to its shareholders. So at the AGM, they apologised for this particular conduct. And since identifying and reporting the conduct to ASIC, they've taken steps to review its pricing promises and systems through the establishment of a pricing task force. So I guess they're doing something now which you'd think they should have had in place previously, but all that really counted in favour of IAL. Other factors, the judge concluded that and accepted the submission by ASIC that the conduct of IAL should be penalised for one course of conduct, because the application of the cupping mechanism was the factual substratum, which was considered to be a unitary factor which led to the contravention. So I guess instead of fining them for a million contraventions, the judge was happy to fine them for one course of conduct. So a single penalty was imposed for the multiple contraventions involved in the proceeding. The conclusion reached by the judge was, on the evidence before her, it was appropriate to impose a penalty of $40 million. And she said something very puzzling in paragraph 81. The evidence permits a finding that even without a substantial penalty, IAL is deterred. A $40 million penalty will remove any doubt as to specific deterrence and secure the goal of general deterrence. So I don't quite understand the first part of that. It's almost like saying I don't need to impose a penalty at all because IL have been specifically deterred by, I don't know, maybe making an apology or bad press or something like that. But clearly I don't agree that a penalty was unnecessary in this case, which seems to be what Justice Abraham is suggesting in paragraph 81. In paragraph 86, she says she's satisfied in the circumstances the agreed penalty of 40 million satisfies the significant element of deterrence required. This is somewhat contradictory to paragraph 81. It carries a sufficient sting to ensure that the parties or others do not regard the penalties amount as an acceptable cost of doing business. Well, I think that's probably right. I think 40 million, most businesses would think that that's not simply cost of doing business unless you're a digital platform or something. Weighing all the relevant factors, bearing in mind the protective and deterrent purpose of a pecuniary penalty, i.e. the High Court's decision in Pattinson, as applied to the facts of the case, I'm satisfied that the agreed penalty is appropriate. So she signed off on the agreed penalty. Now, a little bit of commentary. Now, this is a significant penalty. $40 million is not something to be laughed at. And I think it applied to a financial institution like IAG, which has had a few tough years, I don't think it's insignificant. I think it was a penalty that was going to achieve deterrence in this particular case, both specific and general. It's really hard to understand how the judge concluded and why ASIC submitted that the conduct wasn't intentional. I just don't know how you determine whether conduct's intentional if this is intentional. Clearly, this was devised for the sole purpose of preventing a loss of revenue. It was to recalculate the premiums to prevent customers getting the full benefit of discounts they're entitled to. This is clearly intentional conduct. So I just don't understand the submissions made by ASIC, and I just don't understand the conclusions of the judge. And had it been concluded that the conduct was intentional, it seems to me the penalty would have had to be a whole lot higher. So this is $40 million for what the judge has concluded is an unintentional breach of the relevant legislation. I'm very surprised that ASIC hasn't taken any individuals to court on relation to this matter. It really seems to take individuals to court when it takes large corporations to court. When you see individuals being sued, often they're at the lower end of the market, smaller organisations, and it seems surprising that they're not looking at individuals a bit more. And it does raise the question, I think it does raise the question very strongly, are companies simply paying ASIC, and I think the ACCC is not immune from this as well. I think ASIC and ACCC tend to sue individuals when they're small to medium-sized businesses involved, but often don't take legal proceedings against senior people when they're dealing with larger companies, and that's a concern. So the question is whether these big companies are paying big penalties to achieve two outcomes. A, to avoid admitting the conduct. It's almost like saying, we'll pay you $40 million if you don't insist that the conduct was intentional. So pay you a bigger penalty to avoid saying it's intentional, otherwise we'll fight it out. And also whether they're saying, well, we'll pay you $40 million, but you don't take any individuals to court, leave the individuals out. So is this large companies buying their way out of the full consequences of their conduct? It looks a bit like that to me. And I think both ASIC and the ACCC have to get a bit more serious about when they're taking bigger corporations to court. Firstly, if the conduct is intentional, ensuring that that's part of any settlement agreement. And if the company doesn't agree to admit that it's intentional, then fight the case. Secondly, the absence of senior executives being taken to court by the ACCC and ASIC when the respondents are larger companies is a cause of concern. It shouldn't be just taking executives and managers of smaller companies to court and letting, I guess, the big end of town walk free. I think that's a concern. So that's all I had. It's a very interesting case. Hope you like the pun, the cupping or whupping, and I think it's a good judgment with a couple of puzzling aspects to it. If you have any questions about this particular presentation, feel free to give me a call or send me an email. Bye-bye.